And good Sunday, my friends. It is Uncivil Law. Yes, it is I, your host of all the law-related things. Uncivil Law, me, the one, the only, the best of the law tubes. Uncivil Law. I hope you're just having the most fantastic Sunday, as always, and we are here to record a whole bunch of stories for this upcoming week. It's fun and exciting for the whole family. We got I don't even know how many stories, lots. And we're going to record lots, and then it'll be great. So before I record lots, let me just double check on my calendar because I have something I'm speed dating tonight. And I need to remember what time it is. I think it's 8 o'clock. So I got 3 hours. Something like that. Yes. Okay, great. So I got that, and then I got to see how long is it going to take me to get to the venue. Let's see. All right, so I need to end about 7 o'clock, so we got 3 hours. Okay, fine. We got 3 hours to record stories, and then if we need to record more, we'll record more after that. Yes, speed dating. So for those of you who are not familiar with such concepts, a whole bunch of guys and a whole bunch of girls go to the same event at the same time. And then they put the girls down at tables, and the guys usually are the ones that have to rotate. And usually what you do is you spend about 5 minutes, depends on the event. So it depends on how many people are there and how much time there is, but about 5 minutes, 6 minutes, something like that, talking to each girl, and then you get to rotate to the next girl. So that is speed dating. It's very exciting. And so I will talk to probably something like 10 girls, give or take, tonight in the, hour and a half or whatever it is. Obviously, it's a little variable, but that's basically the parameters of it. Wear the hat, you think? I don't know. You think I should wear the hat during the speed dating? It's definitely sending some kind of message. I'm not sure if it's necessarily the way to go. Anyways, let's go ahead and get started with a whole bunch of stuff. Absolutely wear the hat. Is it rude indoors in Austin? No, I'll lose the hat. Depends how traditional you think the ladies might be. In Austin? Not very. All right, let's go ahead and get started. For today's story, we are talking about the Equal Rights Amendment. This is a proposed amendment that was suggested to the United States Constitution that would explicitly protect discrimination on the basis of sex as a protected category. Now, discrimination on the basis of sex today is just seen as an intermediate scrutiny issue because we have equal protection of the laws. So women, of course, are protected by the equal protection of the laws. But women and sexual-based discrimination is normally viewed as intermediate-based scrutiny instead of strict-based scrutiny, for example, race. So the practical consequence of this bill or this amendment going into effect would be to elevate sex-based scrutiny from intermediate scrutiny to sex-based scrutiny, or to strict-based. Okay, wow. Let me just do this all over again. I can do this. Let me just try this again. Who am I looking to attract? Girls. All right. For today's story, we are talking about a proposed amendment to the Constitution, the Equal Rights Amendment, which is dead. Or is it? As an appeal court in D.C. tries to struggle with whether or not the proposal is still viable or not. So the Equal Rights Amendment is a proposal to the Constitution. That would be the 28th Amendment to the Constitution, which would prohibit discrimination on the basis of sex explicitly. What it would do as a practical matter would be to elevate sex-based scrutiny from intermediate scrutiny, where it is now, to strict scrutiny, the same as race. It would prohibit any sort of discrimination by the government or any of its entities on the basis of sex, unless it could meet strict scrutiny, which is basically borderline impossible. This incidentally would swing both ways, because it would prevent any sort of thing that would harm or benefit either sex on the benefit of sex. So it would be really interesting to see if this actually went into effect, what the practical consequences would be, because I think a lot of people on the progressive side who have been wanting this amendment, if it actually became into be, would be a little bit surprised by how it would actually function in reality, because they would see a lot of benefits that seem to be sex-based, that seem to be pro-women, would suddenly disappear, because they would all be unconstitutional now. That's the nature of amendments. They tend to be a nuclear bomb and just upset everything. But anyways, what its practical consequences are not our immediate issue. Our immediate issue is it still a thing? So the DC Court of Appeals has been asked to decide, at least in part, whether it's still a thing. So let's go ahead and get started with this. A panel of federal judge has expressed skepticism about two states' efforts to enshrine gender equality. And right away, I'd like to note that's wrong. It's not gender, it's sex. I can read the text. In the U.S. Constitution, by getting the federal government to recognize the Equal Rights Amendment decades after it was considered dead. At a hearing Wednesday before the United States Court of Appeals for the D.C. Circuit, Illinois and Nevada sparred with the Justice Department over whether ratification of the proposed constitutional amendment, long after congressionally set deadline to do so had passed, should count for something. So in the preamble to the amendment that Congress passed, they put a deadline for ratification. That deadline has long since passed. Now, in some of the constitutional amendments, they actually put the deadline in the text of the amendment itself. But for the Equal Rights Amendment, they didn't put it in the text. They put it in the preamble to the legislation. That was the legislation to make it thing. So I suppose one of the questions the court has to deal with is there a legal difference between putting in the text of the amendment and putting it in the preamble to the amendment? So that's one of the things they're dealing with. The states are arguing in part that the deadline Congress set for ratification as part of the preamble to the amendment is an unconstitutional encroachment on state power, because it would artificially limit their ability to pass the amendment. But Congress is the one that proposes amendments, or at least one of the mechanisms is the mechanism we've used. There is, of course, the Convention of States. We never actually use that mechanism. So the Congress is the one that proposes it, and they can propose deadlines, and they have in the past, at least in the text. A lawyer for the Justice Department countered that while the Biden administration agrees with the principles of the Equal Rights Amendment, the executive branch can't unilaterally decide whether it's part of the Constitution. I mean, there are rules. Our ratifications have not been given their intended effect, said the Solicitor General of Illinois. Well, the problem is, of course, the ratifications were not sufficient because there weren't enough signatures within the deadlines. The three-judge panel of the appeals court appeared open to the idea that states had the legal right to force the United States archivists to certify and publish equal rights amendments, which is incidentally one of those little curiosities of U.S. law. Like, who gets to decide whether an amendment is part of the Constitution or not? Well, Congress passed a law. And the law says that the archivist of the United States, that is the head of the National Archives, is the person who decides whether or not an amendment has become law. That's just who it is, right? So if you want to know whether an amendment is the amendment or not, you go ask the head of the National Archives, because that's what the statute says. They're the one that gets to decide. So they apparently want to be able to sue to force the archivist to say this is part of the law. But the Department of Justice seemed less sure the position was right, and that the amendment, which is proposed by Congress, but of course needs ratification from 3/4 of the states to become the law, and within the time frame, which has long since expired, has in fact become part of the U.S. Constitution. The legislative history seems to indicate that Congress only passed the Equal Rights Amendment because it did have this deadline. I mean, it is part of the preamble of the thing. It's one of the things Congress wrote, said the judge. If the deadline wasn't allowed, wouldn't then the result be to invalidate the entire amendment rather than just invalidating the deadline? So it's like, if Congress can't do this, maybe the entire thing was void ab initio, which, would be basically the same result anyway. The states disagreed, arguing the deadline in the preamble was simply unenforceable. Why? I don't know, because Congress is the one that proposes the amendments. They can propose to require them to ratify them within a certain time period if they want. And some of the amendments have it in their text. Here, they didn't put it in the text. They put it in the preamble, which is a little bit cleaner. And they're saying, well, there's a legal difference there. I'm not quite sure about that. Judge Nemo Rio suggested the state's interpretation seemed to take us way down a slippery slope in terms of undermining Congress's ability to propose amendments, which is pretty much absolute. There's only one thing that Congress can't propose, that the nature of the Senate, in terms of the nature of who sits in the Senate, is changed, right? They can't deprive any state of its equal representation in the Senate. But other than that, they can do anything. That's the nature of amendments. It's a big explosion that can do just about anything. And so, why can't Congress put limitations on how long the states have to consider this? There's no possible reason. Sarah Harrington, an attorney for the Justice Department, said the Biden administration supports the principles that are espoused in the ERA. Again, if this ever actually became an amendment, I wonder how the progressives would feel about it. Because there are a lot of things in this nation that are explicitly structured to help support people on the basis of sex, usually women, right? The Violence Against Women's Act, for example, or any number of state-based scholarships from public universities for females, or whatever, right? It's like, okay, if you're now elevating sex-based scrutiny to strict scrutiny, how many of these things are now constitutional? Is Title IX even constitutional or not anymore? I don't even know. Because it's a big explosion that undoes everything. I think in balance, if this ever actually became a thing, the progressives would rue the day it became a thing. Because I think on balance, they would find it would hurt them more than help them. The ERA was considered previously expired when it fell 3 states short of the required threshold for ratification, failing to meet the original deadline of 1979, and then a 3-year extension. 5 states since then have also withdrawn their approval, so then you have to get into whether or not those withdrawals count or not. If signatures after the date count, do withdrawals after the date count? So how do you get into that issue, right? So, okay, so that's a whole counting problem. The House, but not the Senate, had previously passed legislation to remove the deadline, which, because it was part of the original preamble proposal, you get into issues about whether or not that's even constitutional. It's like, because the original proposal had the deadlines, like, can Congress change that by mere legislation? All kinds of fun legislation questions, right? You can put a deadline in the original proposal, but if some states sign off on it with that deadline in mind, and then you change it after facts, like, wait, can you do that? Because, like, are you changing the proposal in some ways? All kinds of fun questions. Supporters of the amendment take the view that the deadline and the withdrawals are invalid. So the deadline doesn't exist, and all the states who took back their ratification, they can't do that. Because deadlines are not in the amendment itself, they say that makes a difference, and ratifications are final, which there is some case law to support that proposition, but of course, all new questions when there's specific things in mind. Inspired by these arguments, 3 states ratified the amendments in the past 5 years, ending with Virginia, which would be the 38th state, if it was valid. To supporters, that meant it would go into effect this January, because that's when constitutional amendments would go into effect. They go into effect the next calendar year. But under the Trump administration, the U.S. archivist refused to certify because they're the one who makes the decision. And so the person who was the leader of the National Archives said, no, I'm not going to ratify this, or I'm not going to certify it, rather, that it was ratified, leading to this lawsuit. President Biden's nominee has said that they'll stand by the decision unless the court or Congress orders them to do otherwise. So they're not going to change that decision. It's not even clear that they can change the decision because of, again, it's a constitutional amendment and who gets to make the decision and when it's final, right? There's all kinds of fun questions. The Attorney General of Illinois, however, is convinced the 28th Amendment to the Constitution exists. I am less convinced. The challenge is if you're putting in a protection in our Constitution for discrimination on the basis of sex, like any laws, people look to the books to know they exist. There's meaning in publication. Yes, there certainly is. That's how amendments get notified. They get put in the Federal Register just like anything else, right? The official register of all the business of the U.S. government, right? So if it becomes an amendment, they put it in the Federal Register, and it's not in the Federal Register. So the Attorney General of Illinois thinks the amendment exists, but again, so many problems. The deadline passed in 1979 and then again in 1982. 5 states have withdrawn, or can they? 3 states since then have certified, or can they? So all kinds of stuff. Every other constitutional amendment with a deadline has been ratified within the time frame, so we've never had that problem before. A federal district court last year found while ratification effort is laudable, it's contradicted by a clear deadline. There's no doubt that Congress intended to be binding. So, you could always try again. You can always get those certifications again if you can. And also whether or not it's a good idea. It's like, yeah. While sex discrimination is protected under federal law, the ERA would subject laws that differentiate between men and women to greater scrutiny. Yes, that would be the upshot. It would elevate sex-based discrimination from intermediate scrutiny to strict scrutiny, the same as race, which would prohibit any legislation from any federal, state, or local government that either tried to inhibit or promote any sort of benefit on the basis of race or sex on equal terms. So that would be a lot. Both advocates and opponents believe the ERA would strengthen the argument for a constitutional right to abortion. I don't see how, but okay. Arguments in the case occurred before January when advocates say the ERA took effect. Advocates in North Carolina asked time for the court to argue the court must consider the entire Constitution, which legally includes the 20th Amendment, but of course the Supreme Court said no. And I'm also not clear how it would change it anyway, because it doesn't, just to say we're not discriminating on the basis of sex, but there's case law already saying that it's not discrimination on the basis of sex, and I don't think elevating the standard would change that, but that's a whole nother discussion for another time. Let's wrap that up. Would override Dobbs? I don't think so. Thus, that brings us to the end of the case about the appeals court debating whether the Equal Rights Amendment is really dead or not. I think it is, because Congress has the ability to propose amendments to the Constitution, and they have the ability to put deadlines on those. And those deadlines have long since passed. Also, if it became a thing, I don't think, one, it would do anything to change the abortion cases, because I don't see how elevating the standard from intermediate scrutiny to strict-based scrutiny, strict scrutiny, would infer that there was a right to abortion in any of that. But okay, that's me. And also, I think it would wind up hurting people more than it would benefit, because it would get rid of a lot of sex-based benefits that are currently in place. So I'm not sure it would really do anything that they're proposing to do, but yeah. So at least for the moment, that brings us to the end of discussion of this case. And I haven't really fixed the scroll so much as made it smaller, because it seems to base it on font size. So it's not ideal, but at least it seems to work. Well, almost, yeah. So how far is it getting down? Yeah, it's not. I'm still trying to find a solution to this problem. I'm still trying to find a solution to have something that will scroll all the names, and I have not found it. So if you have an idea, let me know. Okie doke. Let's see what's next. It gets to O. Fuck. Fuck me. All right, let's see if we can fix it. I need to find some way to scroll this together. Hold on. I don't have time for this. Oh, please tell me I got it. Please tell me I got it. Come on. Why aren't you working? Unable to extreme start on your platforms. What are you talking about? Oh, can I not do this inside? Just launch it using window capture. What the hell? Streamlabs.com widget end credits. Why is not working? It'll launch. It'll work. It's just very sloppy. Why is it not working? Okay. Come on. All right, this will work. This is a very ugly hack, but this will work. Oh. Okay. Okay. Oh, did I break it? No. Okay. Great. All right. Great. All right, let's give it let's try this. Okay. I can see your comments. I was just busy thinking. For today's story, we are following up on the Kyle Rittenhouse trial, which somehow still has news. Gage Graskowitz of Kyle Rittenhouse trial fame has filed court papers to change his name because he's sad that people know who he is and he'd like to change his name. So great, Gage Graskowitz may not be anymore because he wants to be known by some other name. Let's go ahead and get started with this story. Here is a picture of a guy now known as, and to soon be once known as, Gage Graskowitz, who testified at the murder trial. So, interesting fun. Is it working? Please tell me I went through all that for a reason. It's not resetting, is it? How do we tell? Let me know if it resets before it gets to Z. Gage Graskowitz, the Wisconsin... I am not in the mood, phone. Gage Graskowitz, the Wisconsin man who was shot in the arm by Kyle Rittenhouse, wants to change his name. That's according to the Milwaukee Journal-Sentinel, who cited a conservative news outlet as the original source of the information. Graskowitz's petition, the Journal-Sentinel has said, was supposed to have been secret, and its leak reportedly led Graskowitz's attorney to call for a probe of how the matter became public. However, the petition is indeed referenced on the public court docket under Graskowitz's name in Kenosha County. So it's a public court record because, of course, it has to be to change the names. You think I got to M's and then reset? The court filing is listed only as a confidential name change. The actual records contained in the docket are fully sealed. Only the docket entry is public. So this would allow him to get his name changed and to have new ID printed, and he could go by a different name, but he'll always be Gage to us. The conservative news outlet in question, the Kenosha County Eye, is reportedly operated by Kevin Mousewins, the former Kenosha alderman who the Journal-Sentinel said to have had asked armed volunteers to defend the city during the period of unrest. Matheson then uncovered the Rittenhouse trial as a freelance photographer and got into a public yelling match with one of the prosecutors. Fun and exciting for the whole family. Graskowitz, who is 29, of West Ailes, Wisconsin, was shot on Sheridan Road in Kenosha after Rittenhouse killed two other men with his AR rifle. The shootings occurred after several nights of what the Journal-Sentinel called protest, looting, and arson over police shooting of Jacob Blake. Graskowitz's attorney told the Milwaukee newspaper that she believes someone in the clerk's county office leaked the petition for the name change to Mouthwin's news outlets and demanded to know who had access to the file. The newspaper indicated that the clerk court was looking into the complaint. Graskowitz reportedly released the following sentiment through Motley to the Journal-Sentinel. Yes, after 2 years of death threats from right-wing lunatics, I made the difficult decision to change my name for the protection of me and my family. But the real story isn't that I'm seeking to change my name, but that the process that's supposed to protect and shield those in danger was undermined, and sealed information was released to right-wing media within hours of my filing. I was told my filing was confidential. I demand the court investigate how this was leaked to ensure those seeking protection in the future receive the protection to which they're entitled. On Tuesday, I was denied that protection. Groskowitz had said that he was in Kenosha to act as a paramedic, though Groskowitz had testified that he pulled his own Glock handgun because he believed Rittenhouse was an active shooter. Groskowitz claimed he didn't intend to use his gun, and that his hand was not positioned to shoot the weapon. I don't know, that's not really what the video showed to us. And that his hand was not positioned to shoot it, but also testified that Rittenhouse shot him when he was admittedly, but as he claimed unintentionally, pointing his Glock towards Riskowitz. Yeah, that's the famous moment where Andrew from Legal Mindset says, that's it. And it's like, yeah, that's a little bit, that's it. Rittenhouse's gun had initially jammed. Groskowitz jumped on Rittenhouse. Rittenhouse shot Groskowitz in the right bicep during the mayhem. So, yeah, that's all kinds of fun and exciting. Thus, that brings us to the end of this article about Gage Groskowitz, who was shot by Kyle Rittenhouse, has filed court papers to change his name after 2 years of death threats from right-wing lunatics. So Gage Groskowitz, shot in the bicep for pulling out his Glock, but not intending to shoot him, as he pointed his gun directly at him, was shot in the bicep by Kyle Rittenhouse and now would like to change his name, and news of this has now leaked. So Gage Groskowitz may soon not be known by that name anymore. What name he will be known by in the future, yet to be decided. But at least for a moment, that brings us to the end of the discussion of this story. We're up to K. This was such a dirty hack. Sandra says, so happy you were streaming on my birthday on Uncivil Law. Happy birthday, Sandra. You saw your name a few times. Yeah, this is such a dirty hack, but I think it will work. What am I drinking? Iced tea. It's Crystal Light, really. It's Crystal Light flavored. It's Crystal Light water, basically. Okay. The Supreme Court term starts the first Monday of October, and we are going to talk a lot about the Supreme Court's upcoming term in a couple different articles. So this article is dealing with the Supreme Court's business docket, looking at upcoming cases that have potential impact towards businesses in the upcoming terms. Things to expect as the Supreme Court begins its new session and on Monday. Let's get started with this. The Supreme Court in recent years has become increasingly skeptical of the power of administrative agencies. Not skeptical enough, in my view. We all know how I feel about Chevron versus NRDC, so we don't have to go into that yet again. In the last term, it restricted the EPA's ability to tackle climate change because of the statute, that the way it was written, and OSHA's ability to limit the spread of coronavirus, again, because of the statute and the way it was written. For many logical reasons. On November 7th, the court will hear a pair of arguments that could make it easier to challenge the constitutionality of two other agencies, the FTC and the Securities Exchange Commission. The cases are both about timing, asking the justice to decide how long people and businesses must litigate with the agencies that seek to regulate their conduct before they can go to federal court. So this is all dealing with when does a decision become final, basically, because at least in the federal system, you have to exhaust your administrative remedies before you can go to court. And so like one of the questions might be, okay, when does that happen? When have you exhausted your administrative remedies? So that's the question in these cases. The first case, Axon Enterprise versus FTC, concerns a firm that makes body cameras for law enforcement. Yeah, that's probably the most popular body cam manufacturer, Axon Enterprises. You see their work all the time. And it was investigated by the FTC as part of a merger review, which is fairly typical. Rather than waiting for the conclusion of the proceedings before the agency, the company tried suing the federal court, arguing the agency's structures are unconstitutional and it does not have the authority to review the merger. So is the agency set up in a legally appropriate way? And we've seen this be an issue before, for example, for the National Consumer Finance Bureau, I believe it was called, which had problems with its structure because Congress set it up improperly. So does FTC have similar problems? I don't know, but that's one of the things they'd like to challenge. A divided three-circuit panel of the U.S. Court of Appeals for the Ninth Circuit said Axion's argument had some potential force. So although it's been rejected by the Court of Appeals, they think maybe there's something here. And so the Supreme Court might want to do something with it. The second case, Securities and Exchange Commission versus Cochran, concerns an accountant accused of misconduct by the SEC and involves a similar issue. The accountant, Michelle Cochran, sought to challenge the structure in federal court before the administrative procedures were completed. The Fifth Circuit agreed she should be able to bring the claims, creating the sort of conflict between federal appeal courts that often prompts Supreme Court review. So yes, one of the issues here is when does your case become final, and even more appropriately, is the agency structure set up appropriately? Is it set up as an administrative agency properly with the appropriate structure? And we've seen this be an issue before. And are the people, for example, appointed by people who have legal authority to appoint? You know, are they created properly? So these issues have been dealt with before and should be dealt with again. So yeah, that's basically what's going on there. On November the 8th, the justices will consider whether states can require corporations to agree to be sued in the state's court as a condition of doing business in the state. So right up now, at least under the federal law, if you want to sue a corporation, you can for sure sue them the place where they're legally incorporated. And you can for sure sue them the place where their principal place of business is, which is usually defined as the place where its C-level officers are, like its CEO, things like that. And obviously, depending on your corporate structure, that can get confusing, but those are the two places, right? Where are you legally incorporated, and where is your principal place of business? So some states want to be able to have the businesses sued in their state, no matter what. And it's like, can states impose that condition? In order to get a business license, you must consent to being sued in our court. Okay, so the case, Mallory versus Norfolk Southern Railway, concerns Robert Malway, a Virginia man who says he developed cancer from exposure to toxic chemicals while working in Virginia and Ohio for the Norfolk Southern Railway Company, which is based and incorporated in Virginia. So you can sue him in Virginia. That would be fine. The question in this case is whether he can sue in a third state, Pennsylvania. Now, why he'd want to, is a whole bunch of issues, like more favorable courts, better statutes, more convenience, whole bunch of reasons. So the Supreme Court has long said that corporations may be sued where they are incorporated and where their headquarters are. That is the law as it exists now. And they may be sued in a particular claim if the case is related to the context within the state. So yes, you might be able to sue a corporation in other states if what you're suing them over occurred within the state. Mr. Mallory over here requires on none of these specific bases for jurisdiction. So it's not you're incorporated here. It's not that your C-level office suite is here. It's not that the product that injured me, for example, was sold here, right? None of those things. Rather, he points to a Pennsylvania law that requires companies that do businesses in the state to consent to being sued there. The railroad has said the law is unconstitutional. It might be. It might be a problem with dormant commerce clause, for example. An illegal restraint on trade, for example. And saying, well, that you have to consent to jurisdiction, which is undermining perhaps the federal court jurisprudence on stuff. Yes! Yes! We are the champions, my friends. Duh, duh. We'll keep on fighting to the end. Da, 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 da. We are the champions. We are the champions. No time for losers. We are the champions of the world. It's an ugly hack. It's an ugly hack, but it worked. It worked. Victory! Victory! Yes! In a brief supporting the railroad, the Biden administration has said the Pennsylvania law subverts interstate federalism by reaching beyond Pennsylvania's borders and allowing state courts to hear cases in which Pennsylvania has no legitimate interest. So yeah, basically what they're saying basically is this is undermining international shoe, which every law student knows. It's an incredibly famous case in jurisprudence, in civil procedure, that says, sufficient minimum contacts. And the problem is here, although they're doing business in the state, it's not as a result of doing business in the state that the injury occurred, right? It's not that the injury occurred in Pennsylvania or they did something in Pennsylvania. It's just because they're generally doing business in Pennsylvania that I can sue them in Pennsylvania. It's like that kind of undermines the international shoe. So I would expect this to be a problem. I would expect this to not pass muster. Flag on the play, excessive celebration. Flag me, baby! Flag me! On October the 11th, the court will hear National Park Producers Council versus Ross, a challenge to a California law that seeks to reduce cruelty to animals by requiring that pork sold in the state come from breeding pigs housed in spaces that allow them to move freely. The law forbids the sale of most pork in California unless the pig it comes from was born to a pig that was housed within a 24 square foot space. But most pigs are kept within a much smaller enclosure. So again, this is potentially a dormant commerce clause problem, right? It's a state imposing a regulation that is perhaps inhibiting the free trade of goods. And so this is a potential problem. These pens, the court, this from AM. These pens, the group challenging the California law wrote in a Supreme Court brief, provide around 14 square feet of space and for hygiene, safety, and animal welfare and husbandry reasons, do not allow the pig to turn around. Okay, so that is the pigs, that's where they are normally kept, and so they're like, okay, this is a pretty big restriction. Given the size of California's market, the pork producers say the state is effectively seeking to regulate business outside its territory. So this is a common issue that pops up a lot with California in particular. Because California is such a big state with so many people, it can have outsized influence. So, and because of that, it can be a burden on interstate commerce. So you do see a lot of these challenges coming from California as a result, not for at least the reasons that California seems to have no problem trying to impose on other states with its will. So yeah, it's not a surprise at all. It comes from California. A unanimous 3-judge panel of the United States Court of Appeals for the Ninth Circuit rejected the argument that the law's out-of-state effects make it invalid. State laws that regulate only conduct in the state, including the sales of products in the state, do not have impermissible extraterritorial effects. A little bit, maybe, but the case law is not quite that black and white. Just because it regulates only conduct within the state does not necessarily mean it doesn't violate Dormant Commerce Clause, right? Because goods are traveling through the state, for example. So if they're trying to burden commerce that's moving through the state or the instrumentalities thereof, or basically, in other words, imposing a tax or levy in a fact or word, then that poses some problems. So there are some issues there. I don't know how that case will resolve, to be honest, but it should be an interesting one to watch. California beef fish, baby. You got it. Pigfish? They could be pigfish. Two cases of social controversy that have gotten a lot of attention also has big business implications. In a majority challenge to affirmative action programs, the court may strike down race-based admissions in colleges. We'll discuss that more in a different article. But whatever happens there might have spill-on effect to other cases. The pipeline of credentialed minority candidates might tighten, defenders of the programs have argued, and depending on the logic of the ruling, employer diversity efforts could also be challenged under federal law prohibiting workplace discrimination. So yes, there are federal laws that prohibit discrimination on the basis of race in employment as well as education. And so, yes, it might be the case that if the educational institutions can't discriminate on the basis of race by giving out preferred positions, for example, on the basis of race, or providing benefits on the basis of race, it would logically hold that businesses can't either. They can't also discriminate on race, so that would be a problem. A brief supporting the universities filed by scores of companies, including Apple, General Motors, Google, Meta, which is Facebook, and Starbucks, said they rely on leading colleges and universities to train diverse leaders, and that radical and ethnic diversity enhance business performance. So they like the discrimination on the basis of race and would like to continue giving certain races certain preferences in the formalized way. Okay. Also of very interesting, let me try that again. Also an extremely interesting case, it's Masterpiece Cake Shop all over again, although even more cleanly on the issue of free speech by businesses. The court is considering a Colorado web designer case. The Colorado web designer is in the business of producing websites. That's what they do. They were approached in order to create a website that would celebrate same-sex marriages, and they said, no, I don't want to create that speech. They were sued on the basis of that, saying, oh, you're discriminating against us on the basis of our sex or sexual orientation in Colorado, right? And so this is Masterpiece Cake Shop, although it's a little bit more clean because this deals with more pure speech, right? It's not writing on a cake. Now it's creating a website. So it's a purer version of that, which is a cleaner case for the Supreme Court to consider. So the Colorado web designer has said, I'm not creating a website that celebrates same-sex marriages, even though state law requires me not to discriminate on the basis of sexual orientation. So the state law says don't discriminate on the basis of sexual orientation, but it's speech, and so they're saying the First Amendment trumps. As a legal matter, of course, the case concerns free speech, and a ruling in the case might allow other businesses. Now, I think this is almost certainly going to be decided in favor of the web designer. And it'll be really, really interesting to see what the language holds, because it'll be interesting to see like how far from the abstraction of speech the logic goes, right? Or whether they speak to the issue at all, right? So they're going to rule in favor of the web designer. I can't see any other solution. And then the question is, how far do they go beyond that to issues like, for example, Masterpiece Cake, which is more of an abstraction, but still deals with freedom of speech issues. So those are some of the business cases that are happening right now at the Supreme Court this term. Have I discussed the FBI raiding the safety deposit boxes? I'm going to. It's on the list for today. You want to discuss it now? Let's discuss it now. I can be responsive to your requests. Okay. What time is the speed dating? 8 o'clock. I got 2 hours to wrap this up. Excuse me. Excuse me. Me. Okay. Thank you, by the way, Deanna, for your kind remarks on the charity stream. I'm really happy with how it turned out. For today's case, we are discussing the recent seizure of the FBI of the safe deposit boxes in Beverly Hills. So as has been covered in the news, the FBI went and seized all the safe deposit boxes. They just took the entire structure out of the wall. They just took the wall, basically, and all the safe deposit boxes from the safe deposit box company. But the warrant said specifically that they weren't allowed to seize the items in the boxes, although they were allowed to do an inventory search. And then they seized the items in the boxes. So one of the questions is, hey, did the FBI lie? Did they exceed their authority? Does it matter? And so the court is addressing that. So let's go ahead and read a little bit more. So this private business is a safe box company. What they do is they run safe deposit boxes, but they're a private company. They're not really a bank. They just do the safe deposit box thing. All right, so they rented to customers anonymously. That was part of their deal. Customers kept all keys to the boxes. The safe deposit box company could only access a box by drilling it open because they didn't have any keys. The facility was also outfitted with significant security, including an iris scan for vault access, hardcore, 24/7 electronic monitoring, 24/7 armed response, and a timed lock on the vault itself. Now, due to the anonymity of we don't care who you are, you can rent a box with us without telling us who you are, the boxes were used regularly by unsavory characters to store criminal proceeds. And this was apparently known and actually desired by the people who run the safe deposit box company. So they knew this, they apparently wanted this, and so they're helping to facilitate potentially illegal conduct. So that's a problem. In fact, the court notes that the company seemingly targeted criminal clientele on its website, noting the less we know about customers, the better, and their service helped customers avoid government agencies such as IRS or attorneys armed with court orders. Yeah, it sounds like you are trying to court a nefarious business. Like, we don't know your names is one thing, but we're going to help you avoid the IRS and court service. It seems like maybe you're doing this with more nefarious intentions. But whatever problems the company had, of course, doesn't necessarily apply to all of its customers. Many of its customers use the service for perfectly legitimate reasons and perfectly legitimate needs. Not all the people who use the company were criminals. Some people just need safe deposit boxes. I vote yes to the hat. All right, we'll take a poll. We'll take a poll. From 2015 to 2019, the government individually investigated criminals that were regularly using the business to store criminal proceeds. Several different agencies, including the FBI, the DEA, and the United States Postal Inspection Service, which always doesn't get enough love because their jurisdiction is the mail, and the mail goes everywhere. So they're a pretty formidable group in my view, had different investigations open on individual customers during the time frame. However, after almost 5 years of investigating individual box holders, the agencies concluded they weren't doing anything effective because the problem was actually the business itself. And so the investigation in the business uncovered the fact that the people who ran the business were aware of and indeed actively solicited the use of boxes by criminals. So that is the problem, right? It's like, yeah, you're trying to be an accessory to people. It's not just that you don't know their names, it's that you're courting, you have knowledge of, and you want to be a place for nefarious people. So that was at least what the U.S. government was telling the courts. The poll question is, should I wear my hat to my speed dating? That is the question. Is the hat good for attracting the women's? If you know proper hat etiquette, wear the hat. If not, then don't. But then I wouldn't wear the hat. That doesn't even make sense. Because the proper hat etiquette says don't wear a hat indoors. But of course it's indoors. So okay. Plus, I think like a real cowboy would wear a hat wherever he damn well please, to be quite honest. So wear the hat and nothing else, that's okay. On March the 9th of 2021, a grand jury returned an indictment against the box company. The indictment charged the box company with conspiracy to money launder, distribute controlled substances, and structure financial transactions. The indictment also included 2 forfeiture allegations, both of which reflected a finding of probable cause that computers, money counters, surveillance equipment, biometric scanners, and the safety deposit boxes themselves were subject to forfeiture as a result of the criminal scheme. Hence, you're not a cowboy, thank goodness. Oh dear, that doesn't sound good at all. The judge who issued the warrants against the company, which identified items to be seized as the safe deposit boxes and keys. The warrant, critically, did not authorize a criminal search or seizure of the contents of the boxes themselves, but did allow the agents to follow their written inventory policies to protect the agencies and contents of the boxes and allow for inspection of the contents of the boxes in an effort to identify owners in order to notify them so they can claim their property. So the judge who signed the search warrant made a special note of saying, okay, I'm authorizing you to take the boxes themselves, the wall they're in, the biometric scanners, the keys, but I am not authorizing you to seize the contents of the boxes. But of course, what did the government do? Seize the contents of the boxes. So that's the problem. The government executed the search and seizure warrants from March the 22nd to the 26th of 2021. Over the period of time, the FBI inventoried the contents of over 700 boxes. In performing the inventory, agents occasionally found letters taped to the inside, purportedly identifying the owners, but then would continue to do the searches anyway. Once they opened the boxes, agents would examine the box contents, take photographs, and show the contents to a video camera to record inventory. But also, after seizing the boxes and their contents, the government initiated an administrative forfeiture proceeding for any box that contained more than $5,000 worth of value. So even though the search warrant they had specifically said they didn't have permission to seize the contents of the box, there's like, oh, we did an inventory search and now we're going to seize them anyway under civil asset forfeiture for any box that has more than $5,000 worth of value. Now, are we saying it's criminal? No, we're saying it has more than $5,000 of value. And those must be the same thing, right? It's not that anyone could legitimately have more than $5,000 worth of value in a safe deposit box. Why would anyone keep more than $5,000 worth of value in a safe deposit box? Apparently, says the U.S. government, confused and bewildered. Okay. Thanks for your nice thoughts about my hot eyes. That's nice. Tell the women the uncivilians say yes. I'm not sure that's necessarily a point in my favor. I still haven't really found a good way to have the conversation about what do you do for a living. It's like, you know, I could just say I'm an attorney, I guess. But it's like I run a YouTube channel. It seems more interesting. It's a more interesting conversation, I guess. I run a YouTube channel devoted to legal education. I'm a lawyer who runs a YouTube channel devoted to legal education. I don't know. I'm working on it. I'm a lawyer, but I also run a YouTube channel to educate people on law. It's pretty good. YouTube lawyer, I don't think that's really the right phrasing. It's not, yeah. Do you want a money chaser or a smart girl? Smart girl. Tell them I teach law. The plaintiffs in the case argue that the U.S. government's actions in the investigation showed a callous disregard to Fourth Amendment rights and are seeking an injunction ordering the government to sequester and return the records generated during the inventory of the search. They argue that the government's search and seizure exceeded the limitations set out in the warrant because they seized items in the boxes even though the warrant said specifically not to, and the government breached its duty of candor by misleading the judge in its warrant application. All right, so let's consider those two factors in play. The first question is whether the government's actions exceeded the bounds of the warrant. The warrant, while authorizing the seizure of the assets of the boxes, did not authorize seizure of the contents of the boxes themselves, but not the contents. Plaintiffs argue the government ignored the warrant strictures against the criminal search and seizures because any purported inventory was a sham, a pretext to rummage through the boxes for evidence. The government counters that the inventory complied with the written policy and was not actually pretextual. YouTube lawyer is perfect phrasing for normal people. I think it creates a misleading impression, to be honest. I really do. I think it's actually not as descriptive as it would be to a normal person. I think what's that is the next logical question. Like, what's a YouTube lawyer as opposed to a lawyer? It's like to say I'm a lawyer and I also run a successful YouTube legal education channel is much more descriptive. So because let me try again. Because an inventory search must be non-investigative in nature, the Ninth Circuit has held that an inventory search is invalid if it's a pretext for an investigative search. An inventory is pretextual when the only reason law enforcement performs the inventory is to find evidence of criminality. There is, however, a critical wrinkle in the pretext analysis because the mere presence of a criminal investigatory motive or a dual motive, one of which is valid and one of which is impermissible, does not render the search invalid. Instead, the court asks whether the challenge search or seizure would have occurred in the absence of the impermissible reason. So as long as the government has any legitimate reason, even if they have illegitimate reasons, it doesn't matter, says the court. And so, like, can you conjure any legitimate reason is apparently the right analysis. I'm a lawyer who runs a successful YouTube legal education channel. I don't have a black cowboy hat. The only hat I have is this one. Whether an inventory search is impermissibly pretextual hinges on one question. Would the challenge search have occurred but for the government's allegedly improper investigative purpose? Here, the answer apparently is yes. The warrant authorized the government to seize the safe deposit boxes themselves and inventory the contents in accordance with standardized policy. The FBI's internal policy requires that when an agent lawfully takes custody of property, he or she must conduct a prompt and thorough search of the contents of property, including searching any locked or unlocked containers. Thus, because the government had lawfully taken custody of the boxes themselves, due to the warrant that searched the seizure of them, the inventory policy mandated they looked at the contents within. The hat will make me memorable, which is important in follow-up dating. If you mix in a lot of words, they'll be forgetful. I'm a legal journalist. And it needs work. The plaintiffs have made much of FBI's policy regarding custody of unknown persons' property, which is alluded to both in the affidavit and warrants. The policy requires agents to inspect the property as necessary to identify the owner, but extend no further than necessary to determine ownership. But plaintiffs ignore crucial language in the warrant and affidavit that, in addition to examining the box contents to identify owners, agents were to conduct an inventory of the boxes, which required them to examine the contents of locked containers. Thus, the fact the agents continued to examine box contents does not indicate an inventory search was pretextual. I'm a lawyer with a YouTube channel. Lawyer with a successful YouTube channel. Yeah, I'm working on it. The plaintiff's other Fourth Amendment argument is that the government misled the judge in its warrant, thus breaching the duty of candor. Specifically, the plaintiff's note in the affidavit states that only the government intended the inventory of box contents, while admitting the fact that investigators were making preparations to forfeit much of the property. Naturally, law enforcement agents may not substitute warrant affidavits that contain materially false omissions. The test for determining whether a false statement or omission is material is whether the affidavit containing the omitted material would have provided a basis of finding probable cause. If probable cause would have remained even if the omitted facts were included, the omission is immaterial. Further, an omission relating to how the search would be conducted, rather than relating to whether the warrant issued, is also immaterial. The plaintiffs do not argue that purported omission, the government had made certain preparation to forfeit the contents themselves, had any effect on the probable cause to search and seize the property, including the boxes. Rather, they base their argument on two Ninth Circuit cases that have identified alternative types of improper affidavits. So this affidavit was not legally misleading because they had probable cause to seize the boxes, and therefore once they seized the boxes, they were going to do an inventory search, and once they saw inside, it's like, well, we're going to seize them. So even though that was their motive the entire time, even if it was, they didn't have to provide it because the ultimate question is if they had probable cause to seize the boxes, which they apparently did, so everything else doesn't matter. Their true motives don't matter. Basically, all that we look to as is typical in these kinds of things is the objective standard of did a reasonable police officer have a legal reason? We don't actually look to their subjective motivations. This is kind of the same thing we do in traffic stops, incidentally, as well. We don't look to whether or not the officer did, in fact, have some sort of improper motivation. We only look to whether or not they could have pulled over the car due to some objective criteria, and we don't worry about the rest. So it's kind of the same standard as to the FBI. We don't care about whether or not they lied on the affidavit or not, even though lying is bad. We only care about if they had told the truth, and they had enough to seize the boxes, so it doesn't matter that they lied. Okay, well, that's the law, I suppose. Here, the admission by the government that they had forfeiture preparations in place did not create a false impression. The affidavit was rife with details of prior investigation into individual box holders that resulted in forfeiture of those individuals, and noted that the agents executing the warrant would inventory the contents of all individual boxes. Any reasonable magistrate would have inferred the inventory could have led to discovery of criminal proceeds, which would lead to forfeiture. In all, therefore, the plaintiffs have not demonstrated either the omission of the government's forfeiture plan from the affidavit was materially false to probable cause because it would have changed the probable cause analysis, or that the government's conduct in the matter was equal to or greater than violative conduct in other cases. Thus, they find the argument fails. For the foregoing reasons, therefore, the court grants judgment to the United States government that this search was totally fine, and the search and seizure can continue of the boxes, even though they lied, because it didn't matter legally, because they had an objective reason to seize the boxes. So their true motivations is irrelevant because they had both legal and illegal purposes, and all that we care about is legal purposes. So ignore the rest, and everyone can go fight over the civil asset forfeiture. Thus, that brings us to the end of the discussion, for the moment at least, over the boxes that were seized in Beverly Hills. This box company seems to have apparently knowingly facilitated people's crimes. That's what we call accessory after the fact, right? Is it legal to run a business in which you have anonymity? Sure. Is it legal to basically, in fact, openly say, please come help avoid the IRS. We will help you avoid the IRS. We will help you avoid courts things. No, not so much. Like you can't really solicit the criminals. So they were engaged in a knowing conspiracy. So we're going to seize all the instrumentalities of their crime, including the iris scanners and the security cameras, and of course the vaults themselves. We're going to seize the boxes, and then we're going to do an inventory, and then we're going to seize any box that has more than $5,000 worth of value and make the owners prove that it wasn't instrumentalities of crime. So that's what's going on in California. It is a depressing story, but that's the law. And at least for a moment, that brings the end of discussion of this story. Man, I'm feeling depressed. I've been feeling depressed for the last week. Okay. One day at a time, my friend. Yeah. You're loved and never alone. Thanks. If I need to talk, DM you, I might do that. Yeah, I mean, I've recently had a very strong track record of being up relatively recently. I do want to point out that like my depression is overall better, and so the fact that I've been down for the last week, I mean, it was never going to be, just every day was going to be awesome. So in some ways, I guess I'm lucky that I don't go through as many depressive episodes as I used to. But it's just the reality of it that it's been a little bit down. I've been killing the gym. Has it helped? Whether or not the gym helps me on any given day, sometimes it's very marginal. So I don't usually feel worse coming out of the gym. That's very unusual. Sometimes it's very, very marginal though. Do I want to get pizza next time you're in Austin? Yes, please. If you are in the greater Austin area at any time and would like to meet up, send me an email or something, and we'll try to arrange something. I'm on the north side of town, so that would be helpful. So if you're up on the north side of town, that would be helpful. But if you happen to be on the north side of town of Austin, let me know. Pflugerville. Yeah, up in that kind of region, up in Domain, Pflugerville. Yeah, all that kind of space up there. Is it depression today? It's depression. It's just depression for the week. I've been kind of in a down space for the last week, but that's just the way it goes sometimes. Is your daughter single, T-Ray? T-Ree, is your daughter single? Does she want a young, attractive, go-getter, lawyer, YouTuber? She's a teacher in San Antonio? Okay, well. She's involved. Fair enough. All right. Primer, don't diagnose me, please, for love of God. I'm timing you out. Bad primer. I don't need you diagnosing me, thank you. All right. Erica Girardi, otherwise known as Erica Jane, is back in the news and apparently has absolutely no compassion or ability to read the room in any way whatsoever, because she has asked a federal judge for her diamond earrings back. Her diamond earrings were seized as being bought for and paid for by her husband, Girardi, who swindled his clients out of millions, tens of millions, if not hundreds of millions of dollars. And these were the proceeds of illegal money. But she wants her diamond earring back. She has no compassion at all. It's apparently very expensive to be her. She wants her diamond earring back. Let's get started with this. The Real Housewives of Beverly Hills stars, Erica Girardi, also known as Erica Jane, is asking the federal judge to stop her from having to relinquish her pair of diamond earrings. The bankruptcy trustee says should be sold to help pay a $500 million debt for her disgraced husband's firm. Yeah. The earrings are already out of her possession. The bankruptcy judge ordered them to turn over last July, and the trustee has been storing them in a safe deposit box that are going to be auctioned off, and whoever wants to buy them can buy on them, and then the money will go to, paying for some of the bankruptcy stuff. Jane's lawyer is appealing the turnover, and in a brief filed saying the trustee can't lawfully claim the earrings because Tom Girardi gave them to Jane in 2007, and any claim is time barred by the statute of limitations. So they're not saying that they're not bought with proceeds of stolen money. They're not saying that the diamond earrings weren't bought and paid for by the injuries from the crash victims or the water poisoning. No, it's just a time bar issue. So, okay, all right. Jane, who was filed for divorce in 2020, was gifted the 7-carat earrings in 2007 by Girardi after a burglar stole a similar pair of earrings he had given her as a birthday or anniversary gift a couple of years earlier. So, okay. But the bankruptcy trustee for the firm Girardi controlled found records showing that they paid $750,000 of firm money for the earrings. They were bought for and paid for by the business, which itself is cheating injured and hurt people out of money. Okay. Erica Girardi's order, let me try again. Erica Girardi's appeal of the bankruptcy order comes as the trustee is preparing to auction the jewelry. On Tuesday, the judge granted the request to hire an auctioneer to facilitate the sale. The auction is currently scheduled to include other jewelry given to the trustee by Girardi's associate last month, described in court documents as a small Tiffany harp-shaped diamond necklace, a small Cartier diamond necklace, a Bulgari pearl and diamond necklace, and diamond stud earrings, approximately 1.75 carats each, worth between $10,000 and $15,000. The source of the jewelry is identified by the trustee only as a former friend of Girardi, but the relinquishment occurs at the same time as Tricia Bigelow, a retired state appellate court justice who had a 4-year romance with Girardi, was handing over property that she had been paid for. So yes, she was apparently having an affair with Girardi. And so she is also having to turn over things as a result of all this wonderful corruption. Try a French martini? What is that? Raspberry liqueur and pineapple juice. That's interesting. Vodka, raspberry liqueur, pineapple juice. That does sound nice, actually. French martini. That sounds nice. I might try that. That sounds nice. How does this differ from anything else purchased and given away with illegitimate funds? They don't track down all the gifts. First of all, I'm not sure they do, or they do. If they can, they might. Sometimes they do. I'm not sure what's going on here, but they might. They might try to claw a lot of that back. If they can. So I'm not sure what's going on here. Erica Girardi's lawyer has emphasized that she has no idea what was going on with her husband's law firm. I'm not sure I believe any of that. And that Girardi controlled all the finances. Her direct knowledge, of course, isn't necessarily needed for the trustee to seek debt compensation through her. Excuse me. Her direct knowledge isn't necessary for the trustee to seek debt compensation through her because bankruptcy trustees frequently initiate adversary proceedings against recipients of fraudulently spent money who are guilty of nothing more than accepting goods or payments without knowing the true source. So yeah, sometimes you can go after innocent third parties if the money that was producing it was created improperly, right? If they're a purchaser for value, incidentally, that might change versus a gift. So if they're a bona fide purchaser for value, they might be able to get good title. If it was a gift, they might be able to crawl it back. So there are some differences there. But they can't take anything. But can't they take anything even if they gave away as a gift? Again, it depends. Like if someone's a bona fide purchaser for value, they might be able to keep it. There is sometimes a difference in law between a person who purchases a thing versus a person who's gifted a thing. So it can make a legal difference. She had a pair of stolen winter insurance to pay for replacement. I can't speak to what insurance she had or not. Thus, that brings us to the end of the case of Erica Girardi, who's trying to show herself just to continue to be the most classy woman of us all. Erica Girardi wants to get her diamond earrings back, $750,000 of value, given by her husband, who almost certainly stole the money because it was paid for by the company, paid for by the law firm. And she wants the earrings back because she's like, I had no idea. I didn't know. Sure you didn't. But she has no problem wanting to be expensive to be her. She'd like to keep the earrings, and so she's going with that plan. We'll see what happens. At least for a moment, that brings us to the end of discussion of this case. Let's just hang for a second. Let's just hang. Let's just talk. So how's everyone else doing today? Is his gift considered fraud or theft? I don't understand the question. Him buying it is theft, but the gift, maybe it's just the way you ask the question. What do I want to talk about? I don't know. Just thought we could hang and socialize a little bit together, maybe. You had a road trip and you're very tired, but you had a great time. I'm glad. Kat says that you need to hug. The sale of your house has lingered for 6 months and it's just getting worse. Man, that sounds rough. That sounds really bad. I don't know what's going on there. Am I nervous about the speed thing? No, not in particular. Have I read any Jenny Lawson? I recommend Furiously Happy. Very funny text is open about mental health. I'll add it to my very expansive reading list. I don't get to read for pleasure anymore. I read so much case law. I'll add it to my cart. Have I read The Subtle Art of Not Giving Enough? I have read it, yes. It's an interesting book. Yeah, it's part of the problem, no time off. Yeah. Do I like pets? They're okay. I mean, keeping a pet is a whole other set of issues. Like, you know, what do you call a smiling, courteous person at a bar association convention? The caterer? Nice. Will I do a stream on Miranda? At some point, sure. Yeah. What games do I like for fun? I've been really liking Witcher 3. I'll tell you what. That's been fun. You want to see me play Ark? Watching good shows? Not in particular. Not right now, no. I'm a dog person. Do I play Skyrim? Skyrim was fun. Steph is having a bad day too. Maybe chat. Was I able to recover from the long charity stream? Yeah, I had a good time. What's my favorite music? Probably bluegrass. The final amount raised, I'd have to check. Last time I checked, it was 13,486, I think. It's still open, so people can still donate to it, but it's 13,486, I believe, was the amount raised last time I checked. Sandra gives 10 memberships. Thank you, Sandra, for your memberships. That's awesome. Did I ever get shoes for Witcher? Yeah. Oh, man, I don't even know if I want to go out anymore. Maybe I need a nap. Maybe I'll try to take an hour's nap before I go out. Have a little food and then take a nap. See if I can get an hour's nap in. Maybe that'll make me feel better. Going out will take my mind off things. That's cool. That's fair. Yeah, all right. I'll go out. I'll go out. All right, we recorded, I think, 3 stories or something, so at some point I need to edit those and put them up because I need the content. If I'll edit them tomorrow morning and start putting them out tomorrow afternoon. I'll probably just wear this polo shirt. I mean, this is clean. Put this on today. Meditate a little, maybe. Well, I used to edit DaVinci Resolve. It's free. Or I'm going to have a little dinner and then I'm going to take a nap. And then I'm going to go out. I've got like about an hour. I can take a nap and then I need to shower and get out. So do all those things. Smelling some good spray. I've got plenty of cologne. We know that, right? All right. I will catch up with you guys later. I've been having a fun time. I hope you have too. Talk to you soon. Bye for now.